ASEC appeal number A006 of 2025. Ferdinand Waititu, baba yao, was cleared in public.
Yes, this is resolution was consolidated.
My lady, good morning. My name is Kalonzo Musyoka. I appear with the following colleagues for the first appellant, Malon, Mr. Kibe Muigai, Honorable Malon, Mr. Kibe Muigai, who will shortly actually be arguing the matter before the leadership. Mr. Wilfred Inyamu. Wilfred. But where we come from, we don't call him Wilfred because we know the name. Mr. Denwa Njiru.
Present, my lady.
Yes.
Senator Dan Maanzo.
Present, Your Lordship.
Yes.
Mr. Ken Echesa.
Present, my lady.
Mr. Ken.
Echesa.
Echesa.
Yes.
And for the third appellant, my lady, Mr. Jeremy Njenga. And first and second, Mr. Sapo. Mr. Swaka is
Kalonzo and your team, you are here for which appellant?
for the first appellant. For Baba Yao, to be more exclusive. Yeah, Mr. Swaka is also for Baba Yao.
Present.
Mr. Swaka,
Mr. Swaka.
also for the first.
For the first,
Just for the first and second appellants.
Yes.
my lady, we have a very important.
Together. Yes.
But it would be illogical for the simple reason that if you say you are relying on this set of petition of appeal, grounds of appeal, and those grounds have not been admitted, then you cannot be able to argue for bail, referring to them as if they have been admitted. That question has to be resolved first. Because now we don't want to be dealt with in a mud or rap situation where we don't even know what are we basing our applications on. So it is those occupational hazard that if it requires us to come twice, we shall need to come twice because of the logic of the situation. It is not possible to say that you are arguing them together and we've not admitted those grounds.
And you seek leave to appeal, and at the same time seek leave, stay execution.
Leave to appeal. Melody, that's why we are saying
No, I just wanted us to understand whether
Yes.
we can handle the two together.
we cannot handle them together because the applications for bail is premised on grounds of appeal that ought to be admitted. Because our right to refer to them is based on admission.
But you have sought leave for them to be deemed as filed.
Yes, but we have not been given leave. It's just like even an amendment in civil procedure. If you want to seek an injunction and there is opposition to an amended plaint where the injunction is sought, you'll have to deal with that issue first of the amendment. So it's actually them who are complicating a small issue.
No, I thought we were trying to save time, but
No, that saving time throws us into a serious matter of logic, which I don't think we can just go
I
into
agree.
it.
I agree.
Yes.
What the kind of protocol? So then we'll hear your application.
Yes.
But Your Honor, my lady, perhaps in the
Yes.
Yes, my lady, perhaps in the interest of saving the time that the respondents are conceding to, how about if the court considers on its own motion, but because all what we are here for is for seeking of leave, why should we consume court's precious time when the court itself can sui motu make a determination whether a right to amend can be denied? So that, your ladyship, then we are saying that we'll be then in sync with the respondents, that we are all saving time, because we shall only be urging the question of leave. And the court can, on its own motion, exercise that discretion.
But your application for leave is opposed, so you have to hear it. Yes. You see, this is not an issue I can exercise my discretion.
Okay, I'm all right.
Because the application for leave is opposed. There are grounds of opposition and
Yeah,
it's a
but-
preliminary objection.
I agree with you, but my lady, if I recall when the last time you were here before you, what was in contention was the manner in which our amendment was worded.
Yes.
So the contention then that day was,
Yes.
should it be a supplementary petition of appeal, or should it be an amended?
Yes.
That's all the only bone of contention. And therefore, if you have brought before you a document that is correctly worded, then I think then perhaps logically to admit that the same would not be contentious.
You see, as long as there are grounds of opposition, what does that mean? The application is opposed.
We'll take your ground. yes,
Unless
your
it
directions.
is by consent, then I have to hear all the parties and I have to make a decision.
Then we'll
Because
take
this
your
is
directions.
leave to amend, isn't it? And it is not automatic.
We'll take your directions.
It is not automatic, and I believe that is why it is opposed. And therefore, we have to hear the application.
Much obliged.
So therefore, I've marked your prayer 2 of the application dated 14th of March 2025 as abandoned.
Yes.
So now I'm giving directions, and we have asked the court we can proceed and first hear the application dated 18th of March.
March, yes.
Yes. So just for clarity,
Yes.
from the respondents. The notice of preliminary objection dated 18th of March. It is just for the application dated 14th of March. That does not affect the application dated 18th of March. Okay. Then, let them parties file submissions for the application dated 18th of March. Counsel for the applicant, how much time do you?
I'll file them by Monday. Could be 28. No. Monday is actually 31st. 31st.
By which date?
By
Monday
31st.
is which date?
31st of March.
Yes, counsel for the respondent on Sundays.
Oh, and we are being told it might be April 3?
It might be a public holiday.
So we can do it by first? First.
First of April.
First of April.
Yes.
And we could file out by the by the 4th. By close of business on the 4th.
If only I knew that parties would file submissions, I would not have to mention this matter again. I would have proceeded to give a date for ruling. And I don't give a date for ruling until I have the submissions of my part.
The nature of the application, you would kindly request the court probably on 5th we come and highlight.
No, I don't want parties to highlight. This is a simple application, Mr. Kidd.
No, it is a criminal application.
But I'm not saying the nature of the application, but what I'm saying, it is not an application that parties need to highlight.
We believe we need to highlight, my lady. You let us highlight, we need to highlight. It will not take
I thought in the
forever.
interest of saving time, we would do better by not highlighting.
My lady, there are always,
And I've always said,
yes.
this court doesn't believe in submission, in highlighting of submissions in all the matters. Okay? Unless you insist, I don't think you need to come and highlight these submissions.
Then you can give us date for ruling.
Yes, as long as you file your submissions on time.
We will.
Maybe we can have a mention if you confirm parties have filed, so that I give a date.
We can do
for
it on
ruling.
5th.
Yeah, just to be sure.
Huh?
Because the problem I get is
Yes.
that when I give a date for ruling, parties don't file submissions on time. When I've done my ruling,
Yes.
a day before, that is the time a party is filing submissions.
In this one, they really want to come out. They really want to come out, so I have to comply. No, we shall have to comply. I'm sure about that.
Unless I give a very clear order. But if I don't receive the submissions
Yes,
on
yes,
that
yes.
day,
Indeed, my lady.
whether you
Yeah.
file them or not, I
That's
will not
right.
proceed.
My lady, may I suggest that you reserve a ruling date, even if we are mentioning the matter, and in that case, we can even mention it virtually without having to appear in court on the 5th.
Then why do I reserve a ruling date if we have to mention? I thought I was reserving a ruling
They
date.
just give us a
Just give us a
ruling.
ruling.
So that we
It's
don't
okay.
have to
That's
again
okay.
mention the matter.
That's okay. ma'am.
That's okay. That's okay.
Yes, but on condition, and I'm putting it on record.
Yes.
Yes, because I hate going back to the drawing board to do a ruling. Because submissions have been filed when I've already done my ruling.
We shall file this one at reasonable.
Yes, so please comply with the timeline so that we save time. Give us a date for ruling. And if there are any list of authorities, please file them together with the submissions.
Yes, we will.
Yes, I'm being reminded that the recess starts the short recess starts from 9th of April. So we have to mention it before then.
Ruling
I
before
mean,
then.
ruling I have to deliver after the recess.
Third of April.
you deliver the ruling on 23rd of April at 9 a.m.
That's right. No, it was not possible to come early.
Sorry?
It was not possible to come early to Vitalia.
We are resuming on 22nd.
Oh,
I've
we are
given you the
resuming on
first date after
22nd.
the
Thank you. I didn't know that.
Yes.
It's okay.
Yes. So on that date at 9,
It will be a virtual or we come to court?
you can deliver it virtually.
Yeah, if you direct that.
Yes.
Although we were assuming,
Yes.
because of the second application, after you deliver your ruling, it might help us if directions on the other application could be given immediately after delivery. Because there are two applications.
You can still do them virtually,
Okay,
isn't it?
that's okay.
Unless you insist.
That's okay. So that's okay.
Yes, because it's just a matter of delivering the ruling and
Yes.
giving directions on the other application.
On the other application.
And the respondents have filed their responses. So it's just a matter of giving directions and filing of submissions.
Okay.
So there isn't much.
Thank you.
The directions to give for the other application. So we can measure it virtually.
Okay.
Okay.
Thank you.
Yes, we are still on for our.
We can leave.
Yeah, we have another
Okay.
matter.
Much obliged.